Hello, my name is Jon Kiddie. I am an advocate at the Scottish Bar with Terra Firma Chambers. In this video, I want to give a presentation about homelessness and the law. I actually originally gave this presentation as a live webinar on Monday 28th November 2022. Unfortunately, on that occasion, the recording process went offline before the end and the presentation wasn't fully recorded. Therefore, I'm now re-recording this version after the original event in order that it can be included on Terra Firma Chambers' website. My original presentation was just one in a series of TFC webinars called Start the Week, all of which should now be available to watch on our YouTube channel. As you can see, I'm using slides. Some of these might appear somewhat technical, but please don't worry about that. If you wish, a copy can be provided upon request, or in the alternative, you can of course simply pause the video in order to examine the slides more closely at your own leisure. Indeed, some of the later slides are included with that specifically in mind, since I don't intend to discuss all of them in detail as part of this presentation. As you can see from this, my first slide, my topic also has the rather lengthy and somewhat grandiose sounding extended title of Rights, Remedies and Reform, Practice and Theory, New Economic Reality and Beyond. Therefore, what I intend to do is to attempt to review homelessness law in terms of its recent direction of travel and also in terms of its current socio-economic context and importance. Moving on to the second slide, you can see I've included some information on my own personal professional background. In essence, I've been a lawyer for over 20 years. Before calling to the bar, I worked as a solicitor for law centres for many years, and I have handled literally hundreds of housing law cases, including homelessness cases. And since calling to the bar in 2020, I've continued to be instructed in such cases, for example, including judicial review. Therefore, as well as these slides, I also have an abundance of additional relevant material. If anyone is interested in instructing me for housing matters, or if you just have any queries about this presentation, please simply get in touch with me through Terra Firma. Now, let's look at some context. Why is homelessness law important, and why do I believe that it shall be of increasing importance over the course of the foreseeable future? As said, I originally presented this webinar on 20th November 2022. In preparing it, I came across an article in the Herald newspaper in its online version published on 22nd November, just 1 week before. And we can see here the very sad headline to that article. Homeless death toll in Scotland nearly doubles in 4 years. On this next slide, you can see I've also included part of the article itself, as well as a link to the full article. So let's just look at some of the statistics here. In the Herald's article, it claims that it is estimated that in 2021 in Scotland, some 222 homeless people died. Most of those deaths were drug related, yet they also included suicides. And that total death count was almost double the number in 2017. This situation has been described as a national disgrace. Now, can I ask, can you please just take a moment to reflect on that figure of 222 lives lost. Understandably, in law, we have to develop a sense of professional detachment. Yet, sometimes looking at situations in the abstract, we can overlook or underestimate the importance of their factual reality. 222 homeless human beings are fellow citizens in a country of ours that has a population of about 5.5 million. That's about 4 or 5 deaths per week. So let's just pause briefly to reflect on that. Now, let's look at some of the causes of homelessness, or factors contributing to it. I worked in law centres as a solicitor for 16 years and dealt with hundreds of individuals facing their own particular personal homelessness horror story across a wide and diverse range of circumstances. On this slide, you can see I've attempted to list some of the more commonplace factors. For example, eviction, which I've put at the top of the list because it's almost certainly the commonest factor. For example, as it affects those who can no longer afford their housing costs, and this includes rent arrears or mortgage arrears. And a significant number of evictions also arise out of allegations of antisocial behaviour. Moving on, perhaps the flip side of someone being evicted as the alleged perpetrator of antisocial behaviour is someone else fleeing his or her home as the victim of antisocial behaviour, or as the victim of domestic abuse at the instance of a partner or family member residing in the same household. Another quite common situation is the grown-up child whose parents put him or her out on the street, perhaps an older teenager, old enough to be put out, yet still young and immature enough that they will struggle on their own. And another situation that I believe may be increasingly significant nowadays is former military personnel who can't manage the transition to civilian life, perhaps compounded by PTSD and/or substance abuse issues. The long and the short of it is that literally anyone can end up in this situation. Now, as lawyers, we might consider it a pretty remote prospect for ourselves, and perhaps it is. Yet I have certainly encountered individuals from quite stable, professional, middle-class backgrounds, and who were superficially economically secure, yet who ultimately lost it all and found themselves homeless. Who knows what the future holds for anyone? Later today, you could be knocked down by a bus, or find out that your partner has been diagnosed with a serious illness, or that he or she has been cheating on you and you're looking at a divorce. All of these are circumstances that can contribute to homelessness. Who has a crystal ball? Nobody. And what you'll also see on this slide is a graphic that you might recognise. I apologise if it's a little hard to read on account of its size. This is the Bank of England interest rate from 2013 to 2022. You can see it's pretty low and flat for most of that period. There's a little fluctuation, but not much. Then, in 2021, it begins to ascend, and it continues to go up, climbing, climbing, climbing. And then in September 2022, as we all know, Liz Truss and Kwasi Kwarteng announced their catastrophic mini-budget, which has triggered the interest rate to shoot up even higher and mortgage lenders to react commensurately. Therefore, unless you're in the fortunate position of having locked down your mortgage rate before this kicked off, then you'll be facing appreciably higher monthly mortgage payments, and these, of course, on top of significant increases in utilities bills, grocery bills, and general living costs. You might be able to afford that, but for a great many other people in similar housing, the current economic factors could be unsustainable. £50 a month, £100, £200, and in some cases, I've heard of it being several £100 a month additional income required in order to meet rising costs. That differential in regular outlay can obviously be a make or break factor for many, and a very real and present danger likely to contribute to homelessness across the country in the next few years. Now, let's look at what your rights are and from where they derive. On this slide, you can see I've included certain provisions from the ECHR. This is really by way of general background, although homelessness cases can engage these rights in a substantive sense, particularly at the level of judicial review. Here, perhaps obviously, Article 8 is the most important, being the right to respect for the home. However, I've also mentioned Article 13, which is perhaps sometimes overlooked. It gives us the right to an effective remedy. And I've mentioned Article 1 of Protocol 1, the right to peaceful enjoyment of property. Now, it bears mention that Article 8 is not an absolute right, but is subject to the concept of proportionality. In other words, interference may be justifiable, for example, having regard to the economic well-being of the country as a whole, and having regard to the rights and freedoms of other persons. The practical reality of the ECHR is that it's the product of a capitalist society at large. Therefore, what emerges is that classic tension between the rights of one person and those of another person, natural or corporate. For example, between a tenant relying on Article 8 on one hand, and on the other, his or her landlord perhaps relying on Protocol 1, and where that landlord might well be a social landlord, and as such, arguably a manifestation of the state itself. Or perhaps between a homeowner and a mortgage lender. And I mention Article 8 in particular for its potential relevance to the question of whether judicial review is an effective remedy in homelessness situations. This is a question to which I will return later. Now, moving on and focusing in on domestic sources of rights. At the heart of housing law and homelessness law, we find the Housing Scotland Act 1987, as amended, and amended, and amended. This statute is not dedicated to homelessness, but regulates a wide range of housing issues, and as such has been amended repeatedly over the 35 years since it's being laid into law. It does a lot of heavy lifting. For example, the recent so-called new law on integrated smoke alarms was actually achieved by amending this now somewhat venerable statute. Yet Part 2 of the 1987 Act is really the heart and lungs of homelessness law. There are various other statutes and statutory instruments, bits and bobs, which have tinkered around with the mechanics of homelessness law, some of which you can see I also mention on this slide. For example, the Homeless Persons Advice and Assistance Regulations 2002, and the Homeless Persons Interim Accommodation Scotland Regulations, also 2002, etc. But the 1987 Act remains at the heart of it all. But before zoning in on Part 2 of the 1987 Act and its sections 24 to 43, it's important not to lose sight of Part 1, Section 1, which makes out the local authority's duty to ensure there is adequate housing provision in its area. This is not a duty to individuals, but a more general duty to take care of the overall housing situation locally. That doesn't mean the local authority must be a landlord, and sometimes that role is exercised by local housing associations exclusively. A classic example of this is the large-scale housing stock transfer from Glasgow City Council to Glasgow Housing Association of about 2 decades ago. Now, moving on, the Homeless Persons Unsuitable Accommodation Scotland Order 2014 is an instrument that has been cropping up increasingly and indeed has given rise to a significant case law precedent in 2022 in the case of X against Glasgow City Council, which I'll come on to mention in more detail later. On this slide, I also mentioned the Scottish Government's Code of Guidance 2019, which is important and shouldn't be overlooked. You'll see its preamble on this slide, which I'm going to read out. However, before I do so, let's just think back to that article from the Herald and those 222 deaths in 2021, almost double the figure 4 years prior. Bear that in mind when I read the preamble to the Scottish Government's code. It says, "The Scottish Government has a clear commitment to ending rough sleeping and homelessness in Scotland and ensuring that everyone has a safe and secure place to live. Our Ending Homelessness Together action plan, which is backed by our £40 million Ending Homelessness Fund, sets out a programme of transformative change to help end homelessness in Scotland. With the assistance of our partners in local authorities and the third sector, we are already making strong progress against the 5-year plan." Now, I'll let you be your own judges as to whether you agree that strong progress is being made. Also on this slide, I mention a couple of case law decisions which have addressed such government guidance and similar. The case of Gallagher against Stirling Council is authority for the proposition that internal policies and procedures may be relevant. However, by contrast, Ellis against Angus City Council emphasises that official guidance is not law per se. Moving on again, and now drilling down deeper into the 1987 Act. As said, Part 2 on homelessness consists of sections 24 to 43. Of these, the first four, that's sections 24, 25, 26 and 27, in effect set out a 4-part test for applying for and qualifying for rehousing on grounds of homelessness. However, nowadays it's actually a 3-part test since section 25 has been repealed. On this slide, you'll see section 24, which sets out the first part of the test, which requires that the applicant actually be homeless or its equivalent. Thus, this section provides certain definitions, and you'll see I've highlighted certain essential terminology in blue. In essence, the Act confers rights not only on individuals who are actually homeless in the sense of not having a permanent roof over their heads, but also on those who are not yet actually in such a situation, but who are nonetheless threatened with homelessness. And here subsection 4 defines threatened with homelessness as being likely to become homeless within 2 months. Typically, this might entail considering a court decree for eviction in terms of what date it stipulates as being the earliest date for actual physical repossession. Similarly, someone might still have a home, yet it consists of accommodation which is no longer suitable for him or her to continue occupying. And that's found in subsection 2A, which was obviously amended into section 24. Here the key issue is whether the accommodation is reasonable to continue occupying. For example, because it's not fit for human habitation, because it's affected by dampness, or by some other type of disrepair. Accommodation that has not been adapted for its occupier's disability needs might also be relevant in this type of case, as indeed might be accommodation which is unsuitable due to antisocial neighbours. And also in section 24, you can see there's reference to vehicles and vessels adapted for human habitation, which can count as reasonable accommodation on condition that the occupier has a right to park or moor in a certain fixed location. Thus, for example, this might include a motorhome or even a canal boat. Moving on to the next slide, section 25 has been repealed as said, so we need no longer concern ourselves with it. Previously, it set out the second part of the test requiring priority need, for example, serious illness, old age, or, at the other extreme, youth and immaturity. For example, the older teenager whose parents have put him or her out on the street, as I have already mentioned. Historically, when Section 25 did apply, often priority need was the hardest part of the test to prove, for example, requiring medical evidence. Moving on, Section 26 remains in force, thus sets out what is now the second part of a three-part test in reference to the concept of what's called intentionality, or in other words, requiring that the applicant should not have intended to become homeless or should not have brought upon him or herself the threat of homelessness. And Section 27 sets out the third part of the test, requiring that the applicant have a local connection to the local authority area where he or she is applying for rehousing, i.e. He or she was previously normally resident in that area, or is employed there, or has family associations there, or some other special circumstances apply. Turning back to Section 26 on intentionality. Why is it called intentionality, and who really intends on becoming homeless? Well, I suppose some people might do so, but that's pretty rare. Yet nowadays, this is often the most important part of the test. So what does intentionality really mean? In essence, it means this: if the applicant is the author of his own misfortune, then the local authority may refuse his or her application for rehousing. This tends to be a question of fact and degree. In extremis, for example, you can imagine a case of an individual who has simply sat back for months and not paid rent with no real excuse. However, in reality, many circumstances are subtler and more nuanced. For example, perhaps due to illness, perhaps depression and anxiety, triggered by change in domestic circumstances such as a family or a household bereavement. When I was a solicitor, I had a case of a young woman with a number of primary school-aged children. The tenancy was in her name alone, yet her husband had been living with her but had left the household. After he left, out of the blue, she received a notice of proceedings for eviction on grounds of several months of unpaid rent. Superficially, this was her fault since she was the tenant. However, the factual reality of her situation was that for all those months, she had been entrusting money to her husband to take to the local rent office to pay the rent. Yet, on each occasion, he had simply pocketed that money to take to the pub or bookies. And when he came back home, he had kept showing her the same old receipt. Thus, she thought the rent was getting paid. Now, due to my firm's acting for her in the eviction proceedings, she didn't in fact lose her tenancy, thus never had to apply for rehousing. Yet had she done so, then it would have been strongly arguable that she had not been the author of her own misfortune. Therefore, intentionality should not apply to her. On a connected note, Section 26, subsection 2 is important, where it in effect requires that someone threatened with homelessness take reasonable action to avoid becoming homeless. Thus, where an eviction decree has been granted, this might entail applying to the court to recall that decree, where competent to do so by means of minute for recall. Or conceivably, it might even entail appealing to the Sheriff Appeal Court, where grounds for appeal are stateable and have reasonable prospects of success. On the next slide, you'll see I've set out the current three-part test somewhat more succinctly. I'll let you look at this in your own leisure if you wish. Suffice it to say, by way of recap, the test for applying for and qualifying for rehousing on grounds of homelessness consists of three parts. First is the applicant homeless, threatened with homelessness, or in accommodation which would no longer be reasonable to continue occupying? Secondly, is this the applicant's own fault? And thirdly, does the applicant have a local connection? Moving on to the next slide. Upon receipt of an application for rehousing, Section 28 of the 1987 Act imposes on the local authority a duty to make inquiries. There are a few practical points to note about this. First, there is no stipulation as to the form of application. While local authorities may sometimes have a pro forma application form available for prospective homeless applicants, there is no requirement to use any such document. A letter should be sufficient. Secondly, any advisor drawing up such an application for a client, even in letter form, should address the 3 parts of the test. Thirdly, Section 28 is a shall provision. It contains the word shall and thus imposes a clear positive obligation on the local authority and an obligation incumbent upon it. Thus, it, the local authority, must make inquiries. I've encountered situations where the local authority in effect shirks or delegates this duty, for example, simply by deferring to a police report, for example, in response to allegations of antisocial behaviour or domestic violence. But in my view, this is entirely the wrong approach, since the police carry out their own inquiries under reference to quite different standards and considerations, i.e. whether there exists such evidence as would prove a crime beyond reasonable doubt, and whether there exists sufficient evidence to corroborate it. And fourthly, and although this might be slightly nitpicking on my part, while the headline to Section 28 refers to inquiry in the singular, the actual substantive content of the provision refers to inquiries in the plural, thus suggesting a somewhat more rigorous investigation. Moving on, Section 29 imposes on the local authority a duty to provide interim accommodation, and not only pending the original application, but also, if that is unsuccessful, pending any internal review process. And Section 30 imposes a duty to give notification of the decision. Section 33 confers on the local authority a power to refer the application on to another local authority where it appears the applicant might have a better local connection with that area. And Section 35A confers on the applicant the right to an internal review such as I mentioned before. And Section 37B addresses the procedure for such a review. Essentially, a more senior decision maker must look at the application anew. Another few practical points to note in this regard are as follows. First, any advisor drawing up such a review application for a client should address the reasons for refusal given in the Section 30 notification. Secondly, this might also entail providing further and better particulars in terms of information stated and or evidence produced. Thirdly, I've come across cases where the application for a review is made by email, say just before close of business on Tuesday, and lo and behold, the negative review decision is intimated by email just after start of business on, say, Wednesday. In other words, it's taken the senior decision maker all of a few minutes to review the original decision. There has been no real further consideration given to the matter. Thus, the review process has been inadequate and potentially unlawful and or unreasonable for the purposes of further judicial review. Section 37 of the Act requires the local authority to have regard to the Scottish Government's Code of Guidance. Thus, although that guidance is not law per se, that's the case of Ellis against Angus City Council, as I'm sure you remember, nonetheless, Absent reasonable justification for departing from it, the local authority might find itself in difficulties if faced with judicial review. And finally, on this slide, if all else fails, then the applicant has the right to proceed to challenge the local authority's final decision by means of petition for judicial review in front of a Lord Ordinary sitting in the outer house of the Court of Session. The next slide returns to one of the statutory instruments that I mentioned earlier, the Homeless Persons Unsuitable Accommodation Scotland Order 2014. This deals with interim accommodation as provided to the applicant by the local authority in terms of Section 29 of the 1987 Act. Thus, the 2014 order puts a little more flesh on the bones. It only applies to situations involving children, i.e. where the applicant or someone residing with him or her has children or is pregnant. So, for example, the accommodation must be wind and watertight. Well, it should be anyway, but this reinforces that point. It must also be suitable for occupation by children, and it must have suitable toileting and washing facilities, and adequate bedrooms and adequate cooking facilities. Accordingly, if you find yourself getting put in accommodation where there's only a microwave and a toaster, is that adequate cooking facilities? All of this is arguable. There is some leeway in terms of Article 7.2 of the order, whereby the local authority can provide accommodation otherwise than in accordance with these standards, but only for up to 14 days. In other words, a safety net for emergency situations. Earlier, I alluded to the case of X against Glasgow City Council 2022, taken to the Outer House by Govan Law Centre. Glasgow City Council attempted to run a defence to the effect that it couldn't meet its duty under the 2014 order due to lack of adequate financial resources. Yet the Lord Ordinary was not impressed by that defence and held in favour of the petitioner. An excellent result for the Law Centre and its client, and an important and highly persuasive court ruling. The next three slides, numbers 14, 15, and 16, I think I've skipped slightly forward to 17, but in any event, slides 14, 15 and 16 address certain further practical considerations and top tips for successfully representing homeless clients wishing to avail themselves of the rights that I've already discussed in this presentation. I don't intend to go through these slides, but you can of course refer to them at your leisure. You can either request a copy of the slideshow be emailed to you, or you can simply toggle back on this video, pause the video and look at the content of the slides at your leisure. Likewise with slide 17, that's the slide currently in front of you, 18 and 19. These provide an overview of judicial review procedure. Again, I don't intend to go through these, but you can refer to them in your own time. And slide 20 poses the question as to whether judicial review is an adequate remedy for homelessness cases. Again, I'm not going to discuss this here in detail. I've written on the question before, for example, in the SMEAL review. If anyone is particularly interested in the question, I would be happy to provide further material or commentary. Suffice it to say, for current purposes, that on this slide I've drawn up a table showing how, for example, a local authority licensing decision can be challenged at the local sheriff court by means of a procedure very similar to judicial review. Yet homeless applicants can only seek their remedy at the Court of Session. This is more complex, more obscure, more expensive, and potentially it entails travelling from any given corner of our country, or indeed island, all the way to Edinburgh, which could be hundreds of miles away. And as a result, we actually only see such cases litigated in front of the Outer House extremely rarely. Does this state of affairs really satisfy Article 13 of the European Convention on Human Rights? I'll leave you with that question, and you can decide what you think for yourself. Thank you very much for taking the time to watch this video and to listen to me. Those who wish to contact me may do so, as said, through Terra Firma Chambers.